Hello, everyone. Welcome to Sunday Sidebar with me, attorney Lakisha N. As you know, for those of you who are new here, this is just a place where you can get access to me, an attorney, and have some of your questions answered in a non-judgmental zone. So we can kind of go back and forth. I'll create the topic, but if there's anything you want to talk about in particular, just got to feel free to let me know. Shoot me an email during the week, give us a call, and let us know, and we will make it a topic of discussion. So just to kind of take it back a little bit, for those of you who don't know me, I've been practicing law now for over 20 years. I can't believe it's actually been that long, but I've been practicing family law in particular for over 10, almost 12 years now. And what drew me into family law was my own personal experience I had in getting my nephew back, who was actually placed up for adoption without my brother's consent. If you don't know that story, you definitely have to check it out. So you have to go to my website, www.lakishadeanlaw, and click on my About Me video, and you'll learn all about what actually got me into family law. But now I'm here. I've been here for a minute. I've settled in. I've tried cases. I've handled all types of cases. And one thing I've seen and I've come to value over my experience is really educating people about the law. Family law is an area where it touches everyone's life, whether it's through divorce, through child custody, child support, domestic violence. It really touches almost everyone I know. And if it doesn't happen to us, then we all know someone who's involved in a situation that has to do with one of those topics. So educating people about family law is really, really important to me because oftentimes things happen in families and we just handle them whatever way we handle them. But there does come a time when someone else is going to have to make a decision about something that's really important to us, our children, our spouse. And that can happen in a divorce, in a custody situation. So when people have a third party making a decision about their lives, it's so important that they're educated about the process. And that's something that we pride ourselves on in my office. So with that being said, that's what kind of led me to create the Sunday Sidebar, just to give people a chance on a Sunday. I do it every other Sunday to kind of chat about some issues that are really important to their lives. And if they do need to take that situation to court, well, then we'll be prepared. So today, one of the things I want to talk about is relocation. And what that means is if you want to move out of the state of New Jersey with your children, how can you make that happen? Now, we do have to talk a little bit about custody when we talk about relocation, because if you have custody of your child, we have to figure out what kind of custody that is and just how involved or what the other parent or co-parent may need, or what you may need from them in order to relocate out of the state of New Jersey. So if you want to move permanently, I can just tell you out the gate that if you are in a situation where you're sharing custody, any type of shared custody at all, even if your child lives with you most of the time, you're going to have to get the permission of the co-parent, or you're going to have to get permission from the court. Now, I know that may seem pretty drastic. It seems like a lot, like you want to make a change. And, just to give you an example of how this happens, oftentimes clients will come to me and they'll have a great job opportunity, even if it's right over the bridge, right over the river in Philadelphia, but they want to move to Pennsylvania. Or it could be someplace much further, someplace I've had a case where it was an international move. Because there's either a job opportunity, someone gets married, maybe to someone in the military, and that's going to force them to move their family, maybe even start and expand their family in a totally different place. And, when we think about on a personal level, it is a big deal for someone to say, you can go, but you can't take your child. And for someone who's really involved in raising their child, that's almost like saying you can't go. So that's why it's so important to make sure you have all of the information you need, get all the education you can before something like this happens and you have to really give up on a huge opportunity. Because if you're not able to take advantage of that because you're not prepared, that can lead to a lot of resentment, loss of opportunity, um, loss of money. So we don't want that to happen. So that's why I want to explain to you today what it takes to be able to relocate out of the state of New Jersey. Now, if you have any kind of shared custody with your co-parent, you will need to get their permission. And I really suggest that you have that conversation first. And if you guys have ever taken a look at my custody success toolkit, one of the main factors that I point out is really important is communication. So if your communication is already at a point where it's not good, it's not productive, it's not healthy, it's toxic, that's going to lead to problems. So communication is always going to be in the background, because even if you are given the permission to leave, communication is going to be key, because that parent, that co-parent is not necessarily going to be denied access to their child. So you guys really need to communicate what that's going to look like going forward if you are permitted to move. So communication is one. But let's say you just don't get that permission at all. Well, then you're going to have to go through the court. And when you go through the court, that's another level of education and preparation that I want you guys to have, so that you don't walk into this blindly, because it can be very time consuming. When you file a motion for relocation, you may get an initial court date. The judge that first court date may be 6 weeks, 4 to 8 weeks later, 8 weeks at the most, depending on the court schedule. And that first hearing may be brief. The judge may want to understand what the issues are, what the facts are, and may also want the parties to consider mediation. Because again, the judge understands that the two of you will need to communicate, regardless of the judge's decision, about this issue, and will want you two to work it out first. One of the main reasons courts are likely to give parties an order to mediate first is because they feel that if the two of you work out your issue, then you're more likely to abide by it. You're more likely to follow an order that you come up with, as opposed to one that a judge forces down your throat, because you know your lives, you know your schedules, you know your children, and you know each other better than anyone else, certainly better than any judge. So let's say you do go before the judge, you may get that mediation date, which you can try to work it out, but if it doesn't, then that's going to lead to a plenary hearing. And a plenary hearing in family court is the equivalent of a trial. And you'll have to bring your witnesses, your evidence, all your facts, all your information together to be able to prove your case. And that's where we actually get to the case law. So now there is case law now that specifically deals with relocating from the state of New Jersey. So this is not an issue in New Jersey that courts just handle randomly. There is case law that lays out an analysis that the court has to go through before it allows a person to move. So the current case law is called Bisbing v. Bisbing. And I'm just going to lay out some of the parameters of that case. I'm not going to do everything, because I think that that would take us a long time here. But I am going to lay out some of the rules of that case so that you guys understand what you're going to need to be able to move. So the test now, Bisbing versus Bisbing is a pretty recent case. It's come about within the past, I'd say, 5 years now. So the standard now has changed in that the party who wants to move has to show that it's in the child's best interest. The standard used to be that you just had to show that it wasn't harmful to the child. Okay, so now you have to show that it's in the child's best interest. That's actually a higher standard. It's one that's a little more difficult to meet, because you have to show that it's good for the child. So many times parents move for their benefit, and that benefit may certainly trickle down to the child, but the focus for the court is on the child. Okay, so, and it does not exclude the parent, because certainly if let's say mom is moving and mom can be in a better financial position, then yes, the child will benefit from that. But we also have to the court's really going to zoom in and make sure that this situation is in the child's best interest. So let me go through some of the things that the court's going to look at and the things that the court has to consider. It's going to consider the party's ability to agree, and here we go, communicate and cooperate in matters relating to the child. Again, communication, I can't stress how important that is. And the courts are going to look, if the court has to decide on something that's good for your child, it's going to want to know, how well are the two of you communicating? Like, can you communicate now about when something happens to your child, if they fall down and hurt themselves? Are you letting mom know? Are you including mom and dad, or dad, on how well you are or not so well your child is doing in school? Because trust me, if you're having problems doing that before the move, you're definitely going to have problems doing that after the move. So that's one thing the court's going to take into consideration. So please, if you're watching this on a replay, or if you're live now with me, work on communication as much as you can. And I know that's not easy. This is not something I know you can do at the snap of a finger, but I cannot tell you how important communication is when it comes to family law. Okay. Another one is the interaction and relationship of the child with its parents and siblings. So there are some cases where children really don't have much of a connection with the parent that is quote unquote being left behind. So if there is that strained relationship, or there really isn't a relationship, I'm not going to say how the court's going to rule. I'm just telling you that the court's going to take that into consideration. So if for parents who are concerned that they're not able to move because let's say mom has really not been involved in the child's life, and dad now has an opportunity to have a great job, in, let's say, Denver, but mom decides that she's just not going to give her consent because she doesn't want to. She may have a vendetta against dad. Well, the court's going to be able to examine that. Okay. If mom has never really exercised parenting time when they otherwise could have while the child is here, that's something the court will consider in whether or not it will allow dad to move to Denver. Okay. So that's something else the court's going to look at. The history of domestic violence. I had one of my early cases years ago that involved relocation, involved a lot of domestic abuse in front of the child. And the court had to weigh heavily about that in considering whether to allow my client to move. And it was a tough case, I have to tell you. It was a really tough case, but that's something that we certainly had to bring out because not only was it about mom's safety, but it was about the child's safety. And I know that oftentimes domestic violence, there may not be any physical abuse against the child, but there is emotional, there can be verbal, psychological abuse that the child experiences if they are a witness to domestic violence. So that's something else that's really important that the court will consider. And again, the one that follows that is the safety of the child and the safety of either parent from physical abuse by the other parent. So again, that's why domestic violence can be something that the courts will definitely take a look at and wants to just make sure that the child is safe. Another one is the preference of the child. If they are of sufficient age and capacity to reason and to form an intelligent opinion about whether or not they move. Now, it's in this kind of case, it's not the determining factor. Trust me. The court's not going to say, okay, the child wants to go, it's a done deal. It doesn't work like that. But if the child is old enough to be able to weigh in, because remember, if we're talking about a 14, 15-year-old child, they have interests of their own. They have a school they're going to. They may have activities, sports that they participate in. They have friends that they may not want to leave. Now, while the court's, like I said, not going to make a final decision based on what the child wants, the court certainly wants to know about that. It wants to know if the child is going to have to sacrifice certain things and whether they want to, how they feel about that. So, if the child is of that age, 14, 15, maybe even 13, the court, it's something, let me back up. The child's opinion is something that the court may consider, but that's not a guarantee. Okay. It really depends on the particular circumstances. There's no particular age that the court will say, yes, I'm going to interview. But it really depends on the particular circumstances. So just keep that in mind. And the way the court does that is, I don't want you to think you can just bring your son or daughter to the hearing, or if it's by Zoom, let them listen in. Please don't do that. There's a special way the court handles the way it communicates with children, and that's usually by interview. So the court will set a date and time for one of the parents to bring the child to the courthouse, or if it's by Zoom, where they will get an opportunity to connect with the court, with the judge, and the judge will interview the child to find out, ask the child questions about how they feel about the move. So there is a way that that's done, and if the parties are represented, they may even be able, through their counsel, to submit questions just to make sure the court is covering things that you feel are important for the child to discuss with the judge about the move. Okay. Of course, the court's going to consider the needs of the child. And I'm going to talk a little bit more about this later in terms of the old case law and what the court looked at, because while the standard is new, there are still some other things that I advise clients about the previous case law, just to kind of incorporate into the preparation of their case and into their case strategy, so that we don't leave any stone unturned. And now I'm going to get to that in a little bit. But the needs of the child are definitely important. If the move especially is being done to satisfy the needs of the child, the court's going to want to hear about that. If your child has special needs, or whether that be educational, medical, and some children actually need to be in a certain physical environment, like under certain, how should I say, like weather conditions or environmental conditions. That's something to consider as well. And then there's another factor the court looks at is the stability of the home environment offered. And that may be a comparison of the type of home and environment you provide now for the child and that you will provide upon the move, and the type of home environment the co-parent provides. So the court will want to examine that and take a look at that. So you have to make sure you're presenting evidence of what that's going to look like for your child. Another factor is the quality and continuity of the child's education. So again, education is critical for children, especially of school age. What kind of school are they leaving? What kind of school are they going to? If they have special needs, will those special needs continue? We know that an IEP, if your child has an IEP, that usually travels with them, but the court wants to make sure that you're setting all that stuff up and that you're just not, moving on a whim and you try to put together the pieces later on. So, these are things to think about ahead of your move so that you can make sure you're prepared for this. Fitness of the parents, I won't speak too much about that here. I think a lot of that goes without saying. The geographical proximity of the parents' homes. So it's one thing to move to Philadelphia, right? It's easy to imagine a court will allow a move from especially South Jersey to Philadelphia. But it's another thing to allow a move from New Jersey to, say, California. Because some judges, in their minds, it's in a way taking away the parent's rights who's left behind. Because you can go from day-to-day contact, day-to-day physical interaction with the child to almost, you can imagine that's going to change drastically. And what that may look like is that they may not be able to see their children. Maybe it's every 3 months or so, or if they can make it work, depending on the location, maybe once a month. But that's a very different parenting arrangement than being able to see your child every day, being able to at least tuck your child in once or twice a week or every other weekend. It's a drastic change to families. And trust me, the courts take this seriously. These are not easy cases for attorneys, for parents, and they're certainly not easy cases for judges, because a judge understands that the decision he or she makes in allowing a parent to move has a serious impact on the rights of the parents who remain behind, but also has a serious impact on the child and their access to that parent. So it's really important that you cross your T's and dot your I's when you're preparing for these types of cases. So if you're close, that can make a difference. And remember, and it's kind of strange, especially like in a state like New Jersey, can be pretty large in terms of distance for parenting. So you don't need permission. And this is what people ask me a lot. You don't need permission to say move from South Jersey to North Jersey. And I realize that that can be further than moving from South Jersey to Philadelphia, but you don't necessarily need the court's permission to do that. But that's also where communication really comes in. Because if you have a co-parenting situation, a joint custody situation, that other parent still has a right to to make decisions with you about that child's education. So while you may not need permission to move necessarily, it may still be a challenge for you to be able to do that if you have to place the child in a different school. So it can be a very similar burden that you have in order to be able to make that move, but it's not a move outside of the state. So again, I say to you, communication is key. Make sure you're communicating with the co-parent, because at least you guys may be able to come up with a way to arrange for the other parent to see the child. If you're just moving up the turnpike, you guys can split that travel and make sure that parent still has frequent access to the child. So again, the extent and quality of the time spent with the child prior to or subsequent to the separation. So I spoke a little bit about this before. How much time did the other parent spend with the child? How much time did the parent who's asking to move spend with the child before requesting the move? I think we make the assumption that the parent who spends more time with the child is asking to move with the child, but that's not always the case. So the court's going to look at how much time each party is spending with the child prior to and after the separation. And then the parent's employment responsibilities. So, and this is a tricky one because a lot of judges don't want to use a parent's employment against them. It's not a crime to work to try to support your family. And sometimes parents have to make sacrifices and make tough decisions to accept a job that doesn't allow them to see their children as often as they would like. So, this is another aspect of these types of cases that makes it difficult for judges, because they want to make sure children have equal access to both parents, given the fact that parents sometimes have really difficult work schedules. So the judge has to balance whether or not, if upon making that move, if the parent's going to spend more time with that child or not, or if the parent that's, being left behind, if they would be able to spend more time with the child, if the child were not allowed to move with the other parent. So these are all the things that, courts are going to look at in making this decision. And again, I just want to reiterate, these are not easy decisions to make. But so that's the case of, I think I basically covered most of the factors that a court's going to consider in the case of Bisbing v. Bisbing. But remember I said the standard changed once Bisbing came to be. Prior to that, there was a case of Bowers v. Lewis. That was the case for years. Now, while that standard is not what the court looks at, there are some things with respect to that old case law that I still like to at least explore and examine with my clients when we're making a motion for relocation, because I think they kind of speak to some of the underlying issues. Like we just went over the factors for Bisbing, but behind those factors, there are things that the court will look at that we kind of touched on before. Now, some of that is, one, the reason for the move. The court really wants to know why move from New Jersey to Colorado? Is it for a job? Is it for a marriage? Because again, you have to remember that while the court is really looking at what's in the child's best interest, the court is not in the business of telling someone that they can't accept a job opportunity. It's not in the business to tell someone that they can't move a certain place. We all have the freedom and liberty to move around the country as we wish. I mean, except for certain circumstances, there's parole and probation and things like that. So there are always exceptions to the rule. But for the most part, the court's not in the business of denying us that. So it wants to know why. It also will want to know why the other party would say no. Okay, so the reason for the opposition. And then whether the child will receive education, health, leisure opportunities, at least equal as to what's available here. So again, remember that these are not reasons that are listed in the new case law, but you have to understand if these are things that we can explore to help build your case, I just don't think that these are things that we can ignore. So that's why I oftentimes will have my clients look at what the educational opportunities are in the state that they want to go to. How would they benefit the child? I think that only helps us build on a case to show that this is in the child's best interest if you can begin to explore and research those things before you get to court. It's important, it's critical. Well, you should do that anyway if you're planning a move, but these are things you want to document and be able to bring to the court to be able to support your case. Very important is whether a visitation and communication schedule can be developed that will allow the non-custodial parent to maintain a full and continuous relationship with the child. This is so important because if you're going to move, remember I said that the other parent can go from seeing the child on a daily, weekly basis to really only seeing them. And this is the way we usually set it up. They will see them. Of course, they'll get that FaceTime access so they can see them and communicate with them every day. But to physically be with them, that may only happen during the child's Christmas break, their winter break, spring break, and summer break. If there's shorter breaks in between, then that would be great. And again, that's why it depends on how far apart the parents will now live. But that's a very different experience than being able to see them every other weekend or every week, being able to pick up your child from school, do homework, have dinner with them. A very different experience. So it's another reason that makes it the court it's so difficult for them to decide on cases like this. So that schedule, you don't want a judge to force that down your throat if you don't have to. So that's really what the parties try to resolve in mediation, is what that schedule is going to look like going forward. Okay. The court also looks at whether the likelihood that the custodial parent, the parent that's allowed to move, will continue to foster the child's relationship with the non-custodial parent. Again, that boils down to communication. You cannot cut that other parent off. It's just really important that you give the child access to the other parent. And the court used to look at the effect of the move on the extended family relationships here and in the new location. So there may be siblings that are left behind, grandparents left behind, or there may be going to siblings and going to a place where the grandparents live and more family members live. And that will give the other parent the support they need to be able to take on the new job responsibilities and still have someone there for the child. So these are definitely things that the court has looked at before. Before the child's age, the child's preference, depending on their age, and whether or not the child is going into their senior year of high school. No judge wants to disrupt that special time in a child's life when they're about to graduate and they're going to get special recognition for their accomplishments throughout their career in high school. Also, it's a time where they're choosing a college and the college is looking at them and making a decision about them. So it's really a tough time for the child to move if they're entering their senior year. And another thing that the courts looked at is whether or not the parent that's staying behind has the ability to relocate. Oftentimes that may not be the case because if the parties have separated, they've kind of gone about and established separate lives for themselves. But it's just something that the court takes into consideration that the parties may not think of ahead of time. So that's basically what you have to kind of consider if you're going to move out of the state of New Jersey. And I know many of you may say, what in the world? I never thought that I had to consider all these things. Well, that's why I am bringing this to you, because I think it's so important that parents are educated about what the law is. Because what may seem like a simple decision, a simple choice, a simple option may not be in the end, especially if you have to involve the courts. So I really hope that all of you were able to gain some insight as to what you need to do in order to prepare for a move out of state. And again, I can't stress enough how important communication is. But we are certainly always here to help you at my office. You can reach out to us and schedule a consultation which I highly advise, whether you do it with me or with someone else, you need to talk to an attorney. Talk to someone who's very familiar. I went through just some of the factors that the court has to consider. But if this is the first time you've heard this, this should not happen for the first time if you're about to move. You need to know what your rights are. You need to be educated about what it is that you need to do in order to be successful when you enter the courtroom, or to be as successful as you can. Because again, sometimes in family court, there are no winners, there are no losers. So you want to just make sure you're as prepared as possible. And we're available to help you create that strategy and go through all of these factors to make sure we're presenting your case in the best way we can to help you be as successful as possible. So you can reach us on my website, www.lakishadeanlaw.com. Give us a call at 856-359-5222. And when you go to our website, you'll find us all over social media. We do reels on Instagram, where we're also offering this Sunday Sidebar every other Sunday. So the next one will be coming up in 2 weeks, and haven't decided on the topic yet, but let me know. Shoot me an email. You can also give us a call and subscribe to our newsletter, where we kind of always drop legal tips for you guys. So enjoy your Sunday. I hope this was helpful, and I look forward to seeing you all again in 2 weeks. Take care.